Wasantha Seneviratne. If I may briefly introduce this young lady to you. She is a senior lecturer at the Department of Public and International Law, Faculty of Law, University of Colombo, Sri Lanka. She holds LLB Honours degree from the University of Colombo, MPhil from the University of Colombo, a well-known attorney at law of the Supreme Court of Sri Lanka, Commissioner of Oaths, and she is presently reading for a doctorate of philosophy in law. She has postgraduate level international humanitarian law, postgraduate level international humanitarian law and public international law specialities. Undergraduate level public international law, international humanitarian law, legal system of Sri Lanka, Roman law, law of the interpretation of statutes and documents, jurisprudence and family law. We call upon the young lady now to address us on this topic. Challenges of realizing the aspirations of Sri Lankans and the question of the justiciability of social and economic rights.
Thank you. Honorable Chairperson, thank you very much for your very kind introduction. Ladies and gentlemen, without going to much formalities, my topic of the day and topic of the title paper that I have written is Challenges of Realizing the Aspirations of Sri Lankans and the question of the justiciability of social and economic rights. Beginning with this statement by Justice Krishna Iyer, decency and dignity are non-negotiable facets of human rights, as our chairperson very rightly put it into words. These are our birthrights. The background of my research paper is in the aftermath of the war, that is the expectation of each of us, being Sri Lankans, to see a rapid development in the country and in order to become a hub in Asia and to achieve a high level of social and economic development in the country. But achieving economic and social development is not that easy, because unlike civil and political rights, which are branded as negative rights or costless rights, realization of the resource-related socio-economic rights in the near future is a tremendous challenge. In fact, that I think the audience doesn't need any introduction about this classification of civil and political rights and the economic, social and cultural rights, but still that I should say for the government there is no any direct cost involved in granting civil and political rights of people, because these are our inherent entitlement, and unless the government or the authorities refrain from the enjoyment of those civil and political rights, that we have the right to get the full enjoyment of these rights. But unlike these rights, in the case of economic, social and cultural rights, that these are resource related. So considerable amount of resources should be allocated by the governments, and if it is not the case, then the people of the country will not be able to enjoy their economic, social and cultural rights. The objectives of the research is to identify the reasons why that realization or justiciability of economic social rights is a challenge at the moment, and to explore the ways of meeting the problem of the justiciability of social and economic rights in Sri Lanka. This is not a question only limited to Sri Lanka, because this is a world phenomenon, global problem, because that no country is having unlimited resources. So the justiciability of social and economic rights remains a daunting challenge for Sri Lanka as well as to many other countries in the world. In the paper that I wrote the paper as a comparative study, and examples were drawn from well-developed legal systems, the established jurisprudence of other countries, regional and international bodies on the issue has been analyzed. However, I have given special attention to the jurisprudence of South Africa and India, because that we find very improved emerging jurisprudence in those two jurisdictions. If I focus your attention to the present constitution of the country, that we find there's one full chapter on fundamental rights is there, but with more focus on civil and political rights, which are negative obligations or negative rights, with less focus on economic and social rights. We find very few, one or two rights in the constitution at the moment. Unfortunately, there is no article or provision on the right to life in our constitution, but we find in India, in South Africa, that right to life is one of the very important constitutional guarantees of the people of these countries. And the locus standi, or the people who has the capability of filing their case, is limited in Sri Lanka. But in some of the countries, like my case studies will indicate you, public interest litigation, that group rights, people that who are interested on common public issues can file cases on behalf of some vulnerable people in the society. Although the jewel in the constitution, that is the directive principles of state policy and fundamental duties, are in our constitution, but those are not justiciable. You cannot get these fulfilled going before courts of law. I want to compare the present constitutional provisions in relation to fundamental rights as well as with special reference to social and economic rights with the 2000 August proposed draft constitutional bill. Many of you may remember that there was an attempt in 2000 August to get this constitutional bill to be adopted in the parliament, but it was unsuccessful. It was during the time of former President Mrs. Chandrika Kumatunga, and by the time Professor G.L. Peiris was behind this endeavor, and we find, although it was an unsuccessful attempt, but we find the chapter on the constitution, chapter on fundamental rights is very much noteworthy, especially with a very broad emphasis on the protection of economic, social and cultural rights, with the intention of to see the justiciability of those rights. Article 8 actually includes the inherent right to life, which was lacking in the present constitution. Article 11 includes right to equality in broad terms. Now we have the right to equality and non-discrimination provisions in Article 12, but rather broad terms that we find in the proposed constitution. Article 22, that includes a very novel provision, that special rights of children and their rights to health, nutrition, education, etc. Article 24 is on social rights, so right to health, right to food, water, social assistance, non-eviction. So you find these are very valuable economic and social rights that has been included to the draft constitution bill at the time. And the protection of the environment and prevent environmental damages and pollution could be seen in the draft. And even locus standi, as I already explained the fact in the present constitution, locus standi is very limited, but there is an ample of avenue in the proposed constitution to the public interest litigation. When a person is vulnerable and has no capacity to come and file the cases, a group of people interested about such a claim can file a case on the person's behalf. At the moment, in the present constitution, we find Article 126, which empowered the Supreme Court granting the fundamental rights jurisdiction, but in the proposed constitution, we find Article 170, one again giving broader jurisdiction on fundamental right issues of the Supreme Court. And Honorable Chairperson, now we understand at the present constitution, only 1 month time is given, although that it is not very strictly interpreted by the Supreme Court, fortunately, but in this proposed constitution, 3 months time has been given for the litigants to file their proposed alleged violation to be questioned. And the Court of Appeal also is given jurisdiction over the rights violation by Article 182. So we find that this has been proposing rather rapid development in relation to the fundamental rights jurisdiction in the country. My analysis has been in the paper, while it is argued in theory that generally economic, social, cultural rights that we say as ESCRs are not justiciable, there is sufficient case law to demonstrate otherwise and to illustrate the potential for future legal action. The case studies explored, as I said, taken from India and even from South Africa, that we find there are strategies envisaged to give justiciability to economic, social and cultural rights even in the absence of those rights, are included into the constitutions of those countries. I have proposing how the justiciability of ESCR rights to be done, and I propose two ways. First, civil and political rights should be construed, interpreted as having persist socio-economic dimensions. In some jurisdictions, these rights have been interpreted to extend the right to non-discrimination and right to equality into the socio-economic arena. And although we don't have right to life provision or very broad provisions on socio-economic rights in our constitution, but we find that we have the provisions at the moment, right to non-discrimination and right to equality. So a broader interpretation of these provisions to construe of having socio-economic dimension would be one of the solutions for the justiciability of ESCR rights in Sri Lanka. Although that we don't have the right to life provision in our country, but the countries like India, that they have used right to life provision to imply by construing to imply the right to water, food, and even many of the environmental related issues are resolved using that is known as green jurisprudence in India. So by using right to life provision, which is originally recognized as a civil and political rights, but to understand a socio-economic dimension and to see the justiciability of those rights. So in India, unlike in our country, they have the public interest litigation through that, which is a non-adversarial approach. They have done a great deal through the interpretation of the right to life. And you find that I don't want to go into much detail of the case law jurisprudence that I have discussed in my paper, but if I take this case, Olga Tellis versus Bombay Municipal Corporation case, well-known case, that right to life has been very broadly interpreted to include the right to livelihood. And in this context, that the eviction of pavement dwellers was actually understood in the broad spectrum of this right to life provision, and the Supreme Court laid down that the eviction could be done only after arranging alternative accommodation to the pavement dwellers. And there are ample of plethora of jurisprudence emerge in India in relation to the protection of environment. So to preserve the right to a clean environment, drinking water, which is a challenge in Sri Lanka also now that we know what happened in Ratupaswala Valiveri area, people are asking for clean drinking water, which is an essential commodity in their life, a pollution-free atmosphere. So these have been done through the broad interpretation of right to life provision. Number two, how this justiciability of ESCR to be achieved is by including economic, social and cultural rights provisions to constitution by granting ESCR a full justiciable status. So we find this has been done in certain countries in Latin America and South Africa. So South African constitution in fact includes key ESCR provisions, including the right of access to adequate housing, to health care, food and water, and to social security. So I think I can't go in much detail, but the Constitutional Court of South Africa has decided in this very well-famous case known Groot Boom case, and said the court held that state is obliged by the Constitution to give effect to socio-economic rights provision in the Bill of Rights, and that the court is mandated by the Constitution in appropriate circumstances to enforce the state constitutional obligation. So similarly, in relation to health rights, in the treatment action case known as TAC case, the South African Constitutional Court held that the government had an obligation to provide antiretroviral drugs to HIV positive pregnant women. So by providing those rights as justiciable in the context of South Africa. The Constitution of Argentina, if I take for an example, is merit-worthy in that one of its amendment to the Constitution facilitated the protection of ESR rights and created new means of legal protection through a collective action which allowed individuals to file the protection of a group. So one of such cases taken from Argentinian jurisdiction is Visconti case, which successfully compelled the government to provide a vaccine to prevent an endemic fever. Now we all are very much suffered in endemic diseases like dengue and other things, I think justiciability of such rights would be a very important thing to a country like Sri Lanka. Coming to the conclusion of my paper, the justiciability of social and economic rights is not a specific question to Sri Lanka, but a common challenge. Nevertheless, in recent years, an increasing number of countries have included social and economic rights in their constitutions. So we also should think of expanding the scope of fundamental right in our constitution by including number 1, right to life, as that we saw in the proposed constitutional bill. Number 2, at least some more ESR rights rather than having 1 or 2 as at present. Domestic, regional and international judicial bodies have adjudicated social and economic rights claims positively using a value coherent approach. This should be followed by our judiciary in cases based on ESR. But I should acknowledge the fact, I think we all know the fact that in Bulankulama judgment, very famous phosphate judgment, Justice A.R.B. Amarasinghe gave a very wide interpretation, very value-based, value-coherent judgment, trying to interpret present constitutional provisions as taken together as a whole, and he argued the fact that those rights inherently include and impliedly include the right to life provision in the country. So it is very noteworthy development in our case law jurisprudence in Sri Lanka. Therefore, Sri Lanka also should keep abreast with these emerging trends and take appropriate steps to introduce necessary changes to our domestic law. Thank you very much, Honorable Chairperson and the participants. I think that by following a broader interpretation approach and having our attitudes towards justiciability of economic, social and cultural rights, and trying to find some amendments to the present constitution or coming up with a new constitution, we would be able to see the justiciability of economic and social rights in the country by making the country to become a very important hub in Asia. Thank you very much.